Have you seen what's going on in the Young Thug trial down there in Georgia? You need to be aware that this could be the craziest trial that you'll ever see. I've never seen anything like it. I believe this is the third attorney that's been arrested in this case. Kind of ethical, professional things that have come up that the judge has been furious about. And now we have kind of a culmination of all that. Young Thug's attorney himself, Brian Steele, being arrested for contempt of court. What was he arrested for? Let's take a look at the videos.
How did you come upon this information?
And I'm going to go ahead and click the like button on this video.
Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who this. Tell me who this information was coming from.
In contempt.
Well,
I'm not
then
answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what. I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me. All of the defendants and then all 26 people are disposed of.
Wow. So he's saying that it's attorney-client privilege. Attorney-client privilege is typically communications between you and your client. Does that mean that Young Thug was the one who was received this information from somebody that maybe shouldn't have told it to him? Or does this mean that Young Thug was listening in? No, we don't know. Probably none of those. And so for this judge to be like just completely taken aback by this, hearing that this ex parte thing happened is a little suspect. I believe Mr. Williams has 2 attorneys. So it's not actually correct totally that he's taken away his right to counsel, but maybe his right to an effective counsel if this Mr. Steele was the main attorney and who was actually planning on the one presenting. Now, I believe there's an attorney on this side of Young Thug who is also his attorney, I believe. So they could say, hey, you need to step in and present it for Mr. Steele, which I think they did. Actually, I think what ended up happening is Mr. Steele ended up being able to stay because the judge thought this is going to be a problem. If Mr. Steele goes, this is probably going to get reversed. So they allowed Mr. Steele to remain representing Young Thug.
All right. Take Mr. Steele into custody, please.
Thug's defense has motioned for mistrial multiple times throughout the trial. Okay. Who is he giving his jacket to?
Your Honor, for me 1 moment to confer with counsel.
I think this is the prosecutor speaking.
Okay. All right.
So he's taken off his tie and his jacket.
Yes, sir. You certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. All of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for.
So let's take a look at some of the arguments for Young Thug's attorney.
Is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
This is a little bit of the thing that when I see this is, why is the judge so confused? Is this the first time he's ever put anybody in for criminal contempt? And if so, why isn't the judge going, I'm going to tell you what criminal contempt is. This is how criminal contempt rolls. This is what we have for our judicial standards and systems that we have in place for when criminal contempt happens. He's relying on this attorney to kind of explain what criminal contempt is when you're the judge. I mean, this never came up before. Nonetheless, it's just a little bit like, come on.
What you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that.
It is Henry McClark.
And that's the interesting thing, because wouldn't it like always happen where this comes up and the judge says, you're in contempt right now. You're in direct criminal contempt. You need to tell me right now. And they say, no, I'm not telling you. Wouldn't that always come up where it would need to go to a different judge? And if so, why didn't they know that? Why isn't this like very clear? Why are they just like, I don't know, which way is going back and forth? It's very interesting to me why this is so complicated for them. Contempts happen every day all over the place. And this attorney, she seems to know what the standard is, but why is this judge not going like, no, you're wrong? It's interesting. It just seems like this is coming up like it's a novel thing when contempts happen all the time.
It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia App.
Georgia App.
372.
Okay.
Also 215. Georgia App. 349. A common proceeding. So most of the cases are a little bit older.
Everybody was pretty upset because he didn't like that she brought up like a 2000 case, and then he cited like a case from the 70s or 40s or something. Anyway, probably not 40s, but whatever it was way longer back than 2000. So I was reading that.
Anybody else? Because I have security concerns as well, and we have to vet people to come in, then they can go to 8H, and they can certainly watch the proceedings from there.
Now, I will just get to the crux of the issue. Okay, what the judge was thinking, because I don't think this judge has really any malcontempt or issue. He just made a boo-boo. But the only argument that I've heard is that there's not enough room because there's so many defendants and so many people in a RICO trial. And so that is an interesting question. Because is it when you don't have enough defendants, or you don't have enough room for all the people to go back into chambers? Are you just not allowed to do any ex parte meetings? Interesting. Now we have the advent of this thing called technology, where you can now be in a meeting without being in a meeting. So that argument is trash at this point. But it is an interesting argument just for the sake of arguing. Is it a situation where the court has to administer justice? They have to keep the flow of the trial going, and to get everybody crammed into a small room and into the judge's chamber. The judge doesn't want to do that just in general, because why? The judge probably doesn't want 30 people in his office, or however many people in this trial. There's a lot of people in this trial. I don't know exactly how many. Just logistics wise, are we about to be in a situation where there's 30 people in my chambers, and we're going through the ex parte order to see if this guy's going to testify or not? We're not really getting into anything crucial to the trial. I just want to make it clear to this guy that if you don't testify, they're going to arrest you and they're going to put you in jail for the rest of the trial. Something like that. So is it necessary that we have to be in there, all of us, for me to do that? Right? There's not going to be any meaningful. It's going to waste everybody's time for me to be in there with you guys making this decision. But it doesn't matter. You still have to. You still have to allow everybody to have the opportunity to say yes or no to this ex parte meeting based on the rules. I mean, if that's the rules in your state, then that's the rule. I don't know if it is or not, because, I'm not an attorney in Georgia, but from a lot of different analysis, from what I've heard, a lot of people are out there saying that this judge, not this guy, he made a mistake, and he probably thinks that at this point that he did. Nonetheless, he's very upset about the fact that he cannot essentially rectify this from happening again. How did he find out? She looked over and she just said, hey, we had this, such and such meeting, and they're talking, just as people talk, are you going to be a part of that meeting? What ex parte meeting? Oh, I guess I probably shouldn't have told you that. That could have been the exact situation that would happen. And then it leads into all this crazy stuff going on. All right, let's just keep it rolling. And I thought it would be interesting to see how AI does in this situation. We are into trying new things at this channel. And one of the things that we're going to be trying is about the AI, okay, going forward for permanently forever. I mean, this is a part of our lives now. So let's just see, will AI go to jail here, or will they be somehow avoiding the situation? And I'm going to be kind of doing this through the perspective of Mr. Steele in a way, trying to see if they would have made the decision as Mr. Steele to not expose that where they learned. And this is going to be kind of tricky because I will admit we don't know exactly where he got this information. So that's something that we won't be able to exactly figure out. So it's going to be somewhat limited, but let's just see, just in general, just assuming that he is right and it is attorney-client privilege or attorney-client work product privilege in that regard. So yeah, it says a judge advised a lawyer not to discuss a certain topic with their clients as it might harm someone. The lawyer, as an officer of the court, must obey this order. However, the judge's actions have raised concerns about potential favoritism towards the prosecution. The Georgia Supreme Court has granted an emergency motion and appeal staying the enforcement of the Supreme Court's Supreme Court's order holding the lawyer in contempt. This decision may indicate the Supreme Court does not approve the judge's actions, which would lead to a mistrial or vacating the contempt charge. The judge's motives for seeking information about the potential leak are questionable. The lawyer's attorney-client privilege should be honored. I put the transcript in one of these videos that was covering this topic into the AI, and that's what came out, and it was pretty close. It was pretty good with that summary, I would say, but that's neither here nor there. Let's just keep it rolling. So let's just say, ask Meta AI, that's what we're using here is the Facebook AI. What do you believe? I hope Meta doesn't reach out to me and make me take this down. That would just be my luck. But what do you believe a attorney should do when they find out that the judge and a witness for the prosecution with a prosecution agreement, okay, met ex parte without any of the members of the defense present? And let's find out. What are you going to do? I think it's going to probably say you're going to, probably take it up to the next level. But let's just see here. Okay, object. Immediately object to the meeting. That's what he did. And any information shared citing violations of due process and the defendant's right to a fair trial. This is not fair. If you're meeting with the witness, for any reason, I think Meta is agreeing with that. Meta AI. Request disclosure, demand full disclosure of the meeting's content, including any evidence or information shared. Seek recusal. Ask the judge to recuse themselves, citing bias and appearance of impropriety. I think they've gone through all of these. File motions for a mistrial to strike the witness's testimony or to suppress any evidence presented. And it's amazing to me, how fast all of these things have happened for the defense. And I think they're acting with, I don't know, a fervor. Is that a word? Fever? Insofar as they're really mad. They're really upset that this happened, and understandably so. Okay, now lastly, file motions. File a motion for a mistrial. The witness's testimony is to suppress. I might have already read that. Appeal. If necessary, appeal the judge's decision to a higher court, which we know they did. And the Supreme Court said, I think, according to the last video, the transcript was like, you can't, you cannot file and hold him in contempt for this indefinitely. He should not be in jail while you're doing this. I think that's what the Supreme Court found. So correct me if I'm wrong. I haven't really looked too far into that, and I really haven't heard a lot on the news about that. But I think that is something that I've heard from lawyers and sources that are maybe not actual news per se. The attorney should vigorously advocate for their client, to ensure a fair trial, free from judicial bias and improper ex parte communication. This is interesting. So Meta AI is throwing that in there. Free from judicial bias, because when you meet with the prosecution team with their witness, trying to get them to force them to testify, is the perception that can lead to you're looking like you're judicially biased, or improper ex parte communication. And that's an interesting thing. That the judge's point of view is this wasn't improper. It can't be improper because it was just like a calendar thing. Like, hey, we're in between there and say, hey, judge, I got to put this on your calendar. Okay, talk to my clerk. Yeah, so on and so forth. You can do that all day long, but you cannot have things that are crucial to the outcome of the trial, for sure, and then just anything that is going to be critical to the proceedings, I think, is what that is. But that seems like going to encompass a lot. That sounds specific, but it's not going to be specific. A lot of things are going to be critical to the proceedings, because to the defense, everything's critical. I mean, any one thing, because it's so difficult to overcome the prosecution and to actually present the defense, that anything that you're going to want to know about. And really, the defense should have the opportunity to decide, or to at least be made aware of it, so that they can object to say, hey, I wanted to be there or not for this meeting. So I get it. I get both sides of it. And interesting. Meta AI, interesting. Let's just follow up here. What if the judge says that he cannot fit everyone in his chambers? Oh, my chambers for the meeting, for the ex parte meeting. And that's why he did it secretly with just the prosecution. I'm sorry, guys. Secretly. Okay, that's why the secret meeting. The attorney should strongly object. So they don't like that excuse either. Request a larger space, demand equal access, file a complaint, appeal. So they're not taking, in no such way is Meta AI believing that was the case. So, I mean, there you go. If you're wondering if AI can be making good or bad decisions in these situations, or, making decisions as actual attorneys would make, it's sounding a lot like Brian Steele right here. It's sounding a lot like the attorney for Young Thug, and very much erring on the side of caution, making sure that you are not getting caught up in a situation where your client is just getting bulldozed by the prosecution. Because, and I'm sure the judge didn't think about this in that regard of optics, because he thought it was going to be secret. And the judge probably does this, from time to time, like many judges do, like, hey, we need to get this done, and it's not critical. It's not going to really matter. But nobody ever finds out, so it really doesn't matter. But once somebody finds out, then the optics are, well, you're meeting with the prosecution without the defense there, and this witness is refusing to cooperate, and you are literally looking them at. And I really hate it. And I'll tell you why. This is a really bad authoritarian situation. Okay, it's a bad look for authority figures everywhere. And I've seen this happen so many times in my personal experience where an authoritarian figure puts the pressure on somebody because they think they can. Okay, because they think they can. You know, they put pressure on who? On the individuals for no reason. For no reason. Okay, did this defense witness need to be in chambers with, excuse me, a burp, with the defense attorney not present? Maybe, maybe not. But what if the judge was looking at the defendant and saying, hey, I'm going to put you in jail till the end of the trial if you don't testify. Okay? He doesn't need to say that to the defendant. The defendant can figure that out. I mean, it's one of those things where, you know, you talk about it in front of everybody in court and you let the defendant know that that's what's going on. He's very clear of it. I think they talked about that a few times. They don't need this secret meeting to then put what could be construed as even more pressure or unnecessary pressure on the defendant without the presence of defense party to really oversee and make it clear that that's happening. And this happens with authority figures everywhere where they go, you're going to do something that I'm telling you to do. And if you don't, you're going to jail. It's so messed up that people do that. And honestly, I think that it should be against the law. I'm just going to put it out there. It is not right. There should be a criminal offense. In fact, that's what I'm proposing right now. Criminal offense for anybody who looks at somebody in the eye and says, I'm arresting you unless you say this. I don't even care if they've done it or not, or if it's true or not, because the reason why they're doing that is because they don't know. They want to get something their way and they don't know if they're right or wrong. They just are going to make them say it no matter what. So it's a personal feeling, a personal opinion, but that's my experience. It happens and it should never happen. And it should definitely not happen in this context. Now, I'm not saying that did happen because I really don't know. I don't know what that meeting was about or what actually happened in the meeting because they won't release what actually happened. But something happened and it's not a good look. It's just not. So that's, we'll cap it with that. And yeah. Okay. One more thing here. Okay. I'm going to go off of what I've taken down here. So, what if the judge says it's criminal contempt, not civil contempt, because asked the defense attorney how he came up with that information when it was supposed to be ex parte and private, and the defense attorney said that it's attorney-client work product. Privilege. There you go. If the judge claims the defense attorney's refusal to disclose the source of information is criminal contempt rather than civil contempt, the attorney should reiterate privilege, assert the information is protected by attorney-client work product privilege and cannot be disclosed. Challenge jurisdiction. Argue that the judge lacks jurisdiction to hold the attorney in contempt for criminal contempt for exercising their ethical duty to maintain privilege. Now, I haven't heard that. That's interesting. I don't know if that's a situation in Georgia that, or something that they've thought of, but maybe I just came across something that things like that. Like we haven't heard anything about that, and maybe there's something there. We don't know. Then you go to the next thing. So you hear it, you learn about an AI, and you're like, that's going to trigger some other things. And you know, the real thing is, if it's an ethics question, there's a bar association. Okay. You can, and there's procedures for that. If the attorney-client work product, has to be breached, the judge could do it. Now, the interesting thing is, I think that the judge probably is missing an opportunity here to just take Mr. Steele back into his courtroom in camera and just do another ex parte meeting with nobody else but Mr. Steele and just figure out what happened and see if they can work something out. That didn't happen here. So it's an interesting thing how they did the ex parte meeting to meet with the defendant to essentially, I think, tell him like, hey, these are the consequences if you don't show up, and to really figure out if he's going to show up or not. But for this situation, we're gonna do it all in public and make a big deal about it and take him to jail. Okay. Anyways, seek clarification, request clarification on what specific conduct is alleged to be criminal contempt. And I think that's pretty clear. The criminal contempt was the judge looking at him and saying, "You need to tell me right now how you found out this information." Demand due process. The judge said the contempt was that the attorney did not tell the judge when asked how he came to find out this information. Okay. Consider an appeal. And that's really what it is. So the Bar Association does the ethics, but really the ultimate arbiter of the ethics and whether or not you can disciplining attorneys is the Supreme Court. So there's the other thing is you can say, hey, let's bring this up to the next level and figure out who really should be, if this is a real problem or not. And the Supreme Court is going to be the ultimate arbiter of that decision. It might not be looked at right away, but if this were some kind of an issue with this attorney, which it probably will, I'm guessing in the situation it's probably pretty split. Either one of them are wrong. I think the judge is wrong or the attorney's wrong. And from a lot of what I'm hearing, people are thinking the judge is wrong, but we will probably find out. Consider an appeal, demand due process, insist on a fair hearing with notice and an opportunity to be heard before any criminal contempt charges are pursued. Another thing that happened here, they said, look, judge, we need a fair trial. This is now a allegation of criminal contempt, keyword being criminal. And when you're accused of criminal behavior, you have to get a hearing and you have to be able to obtain counsel, right to obtain counsel, right to, confront your witnesses, all of that in the hearing. And the judge is a witness. So how could he do the hearing when he's the witness? That's an interesting point. And that's what the attorney for Mr. Steele said. Now, I think that she was like an attorney with the Bar Association, probably, or not the Bar, the Public Defenders Association, and, probably they're stepping in when defense attorneys get trouble, which is probably a good thing to have for situations specifically like this. So let's go ahead and follow up. It says changes the scenario. Now, this is one of the issues with AI. You push back a little and you say, you give them some more information and it changes something. And then they're like, the AI goes, oh, you're right. And then they change their mind and they go, down this line of thinking, which they were spending the whole time thinking that the other thing was right and not being very firm. Okay. I think that's one way to put it is they're not very firm in their beliefs. If you push it a little bit, then it's like, oh, maybe you're right. And then they start thinking down this other creative scenario of how it can be right. But let's see how we do here. Reiterate privilege. Again, assert the information is protected by attorney-client work product privilege and cannot be disclosed. Explain ethical obligation. Clarify that an officer of the court, they have a duty to maintain confidentiality and privilege, even if it means not answering the judge's question. Apologize for any perceived disobedience. Express regret if their silence was perceived as disrespectful, but reiterate their ethical obligation. Now, I don't think he did any of that. I don't think there was any apologizing. He did say he doesn't want to be found in contempt, which I thought was interesting. I probably would have myself said, I'm sorry, judge, but I am under ethical obligations to not disclose attorney-client work product privilege, and I need to probably obtain outside counsel to figure out if I can disclose this or not. So can I have maybe some time to figure that out? because there's no way I can just in front of you disclose this when I know off the top of my head everything in my being that this would potentially lead me to a breach of confidentiality. And, you know, the allegations here are very serious. They're criminal allegations, like criminal contempt. Like, you know, I think that they mentioned that the judge was saying that if it was an eavesdropping, that they potentially either eavesdropped or somebody told them that shouldn't have told them. And well, eavesdropping would be a crime, big time. And so, you know, it's very serious. You know, that's the allegations against them. And that's what the judge is like, it's one of these two things. And I think it's probably the other thing. But a request to reconsideration. Ask the judge to reconsider the contempt finding, given the attorney's ethical duties and the privilege asserted. Seek legal counsel. Consider consulting with another attorney and seeking guidance from a legal organization to ensure that they are meeting ethical obligations. And that's what the other attorney came in from the, I think, Public Defenders Association, and she did a really good job. I mean, she came in and just kind of laid it all out there. Like, Judge, you can't just throw attorneys in jail. You know, and I think what this really gets to and why this situation was so surprising is because he went to jail. And I think there's judges all over the country who are probably going, I cannot believe they did that. And the reason being, and this is just a kind of an overarching reason, you know, kind of a, you know, philosophy type of reason, not a rule, but just in general, it's a hard job to be a public defender. It's hard. And it's not the sexiest job. You might think it's sexy to be an attorney for a rapper, you know, who's doing this public defense. And there are attorneys out there, but most public defenders are not attorneys for rappers. And they are doing this. And I think that this comes back to the very beginning. One of the first videos I made on this is one of the attorneys was complaining about getting paid and saying like, hey, do I need to start an OnlyFans page? She literally said that. I think that was this trial. And she was kind of kidding, I think, but in all seriousness, she was like, I can't even afford to do this. This is taking so much time. And I don't know. I haven't seen her in this trial. So maybe she got released and maybe somebody else took over. But nonetheless, it's not the most lucrative job unless you are, you know, obviously Brian Steele, I'm sure, is getting paid handsomely. Don't know what that is, but I can imagine. And it's not the easiest job. I mean, it is challenging to represent against defendants against state. State has a lot more at their disposal. I mean, they have a lot of resources and they do a good job most of the time, and they have a very high success rate. So you are going up usually a losing battle for low money and a high stress job, just by the nature of it. You're dealing with people who have a lot to lose. I mean, they are losing their freedom potentially. So what do you not need? You don't need attorneys in the courtroom fearing that they're going to be arrested. What the hell? I mean, that is not where you want to be, especially for an ethical obligation. We want attorneys to be ethical. So if you have a question of, well, is this attorney doing the right thing or the wrong thing? Based on ethics, they need to be using a lot of discretion and doing a lot of thinking before they proceed. I mean, I think this was just on the spot. You know, hey, I didn't like that, and now we're going to put you in jail. No. I mean, that is just not something that I think any judge. I've heard, you know, judges just like, you know, you miss a court hearing or whatever, which happens. You know, they're not going to put out a warrant for you, but they may make that joke like, hey, you know, we're not here to put attorneys in jail. I've heard judges make that because, you know, you're always so apologetic when you miss a hearing. And I've, you know, for whatever reason, it happened. Not this judge. He's serious, you know? And I've heard this judge, another attorney was like, Judge, I can't make it. I'm not going to be able to make it to this hearing. It's just not humanly possible. And the judge's like, deal with it. You know, the guy's like, I put it in 4 months ago or whatever it was. It was a long time before this. a notice that I'm not going to be available for this date. I have to be on an airplane. I have to go somewhere. It's all paid for. I got to go. And they're just like, you got to deal with it. Find somebody else to be here or you're going to be here. It's like, I mean, what does the judge do in that situation? Are you going to arrest the attorney for when he put in his notice of appearance? What if he's got something that he really can't miss? That happens in life. For what, you know, a funeral or something that is just like once in a graduation or whatever. You don't get to repeat those. You only get one high school graduation, for example. You know, and the judge was just like, So this judge is very much, I think, pissed off about all of the shenanigans that have gone on during this trial. And there have been a lot, you know, defendants, members of the staff. I think somebody got arrested for bringing in drugs. I don't know if it was drugs, contraband, whatever it was, trying to sneak that in for, you know, into the jail for the defendants, whatever it was. I can't remember exactly what it was because I'm not an encyclopedia on this exact trial, but I know there's been crazy stuff. This is one of the craziest trials maybe we'll ever see. I mean, this is kind of a bizarre scenario where you've had 3 attorneys. I think one of them was Nicole Fagan. The other one was one of the other ones who brought in some kind of prescription drugs to the trial that weren't like his drugs or labeled right. I don't know. Like I said, I can't remember exactly what happened there either, but he was arrested. And now we have a third, 3 different occasions, 3 totally separate things, all arrested in the same trial. When has that ever happened? Probably never. And has it happened where attorney's been arrested? Yeah. Probably for similar things like, hey, all of them were acting crazy and doing things. I don't know. Maybe they got in a fight or something. They were arrested. Not like this. Not like this where it's just like newsworthy craziness over and over and over. And it's like, the judge is done. He's done. He's tired of it. And he's like, I'm going to make a point of everything at this point. And that's just too bad. You know, a judge, you know, I would hope just every day you're waking up and you're going, I'm a judge. I'm a neutral referee. This is like a basketball referee, or it's like last game. I'm not holding a grudge from last game to this game. You know, it's a totally different game. The players are different. And I know you're like, well, the referees on basketball games or whatever, they do that. You know, they're mad at the guy because he called him a bad ref. You know, that's a really nice curse word there, bad ref. But it's different now. You know, it's a new game. You know, you know, and that's probably a pretty fair example where it's like the judge needs to be like, okay, the past days, the past hearings happen, but I'm not going to continue to now hold it against them. And, you know, the bias question comes in. And so you have to avoid that. And judges, I don't think understand, like as an attorney, you don't get how much power you have. I mean, it is crazy. You look at people and they just shake. I mean, they will just absolutely melt in just whatever it is. And if you give any type of impression that you are biased, anything comes out like you're biased, boom. People are just going to snap their heads looking at you like, okay, this defendant's guilty. When this defeats the whole purpose of the trial. So it's really, really critical where, you know, the judge cannot show any forms of bias. I mean, that just makes it unfair. That's obvious. So what do we have here? If it was a situation, the question is, we don't really know if he was biased or not. But if it was a situation where he's like pressuring this defendant to testify, and pressure is weird. I mean, we weren't there, so we don't know what pressure, but any level of pressure is bad, inappropriate. I'm hoping we figured this all out. I'm hoping that the judge gets what he needs to, you know, releases everything, and we get to see everything that happened. And hopefully we will. And I think the judge is open to that. He's like, if I did something wrong, there's a process for that, and they'll figure it out. And unfortunately, it looks like Brian still got caught in the crossfire in the meantime. So if you want to follow this true crime story and more, go ahead and subscribe to the channel. Check out more true crime by clicking on the video right over my shoulder. And true crime continues with Lawyer Cliff right now.